if I get hungry, I was just metabolism of a hummingbird when I was a teenager, so how that go, but
The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Can you put, we'll just hold for one moment while we reconnect Judge Lewis. Your Honor, so we can proceed whenever you're ready.
Oh, thank you. Good morning. We have one case scheduled for oral argument this morning. The case of Ireki Feldman and Feldman Architecture versus Florida Department of Business and Professional Regulation. We've allocated 20 minutes per side. Ms. Pereira, would you like to reserve some time for rebuttal?
I would, Your Honor. 10 minutes, please.
So noted. You may continue, Ms. Pereira.
Thank you. I am Diane Pereira, and I am counsel for Enrique Feldman, and may it please the court. Mr. Feldman is a citizen of Venezuela. He is a licensed architect in Venezuela. He has designed multiple projects throughout the world, including Venezuela, Aruba, Colombia, as well as the state of Florida. In Florida, the type of architectural services that he has performed is authorized by law. It's authorized by statute. It's authorized by Florida statute section 481.229 sub 1 sub B. And that particular exemption from architecture licensure in the Florida statutes permits Mr. Feldman to prepare plans and specifications for the construction of 1 or 2 family residential buildings, including townhouses. Mr. Feldman has made his living since being in this country by doing that type of work. Mr. Feldman is in this country on a specialized visa that recognizes his skill and his expertise in the field of architecture. Mr. Feldman is an architect.
Well, let me ask you that, counsel, if I can. I mean, under your argument, I'm an architect too, right? I mean, I understand your client is an award-winning and licensed architect from Venezuela. But under your argument, me or anybody else that wants to put a home design under the 1B exception is an architect. Is that right?
I think that anyone who can perform those particular services under the statute, I think, yes, they could refer to themselves as an architect. The importance of Mr. Feldman's case and limiting it just to this case is that he is truthfully, he is an architect, and he is holding himself out as an architect. And it is commercial speech. It's true. And he is representing a lawful activity that he engages in.
Well, can I ask you, under 481-203-2, architecture is defined, and being an architect under paren 1 there is a person engaged in the practice of architecture. Are there not some things that Mr. Feldman is not legally permitted to do, such as the administration of construction contracts?
Well, he can oversee the construction of the 1 or 2 family dwellings, as well as the townhouses that he is allowed to design. Now, if that extends into construction administration, I don't know what oversight is compared to construction administration, but I would like to point out, Your Honor, that one thing that Mr. Feldman cannot do, of course, is sign and seal the 1 and 2 family dwelling structures that he designs. However, the issue is not the protection of the public, because the Florida Board of Architecture and Interior Design has promulgated rules, and this is touched on briefly in the answer brief and in the amicus brief. The Florida Board of Professional Engineers has promulgated rules in 61 G116 for their own architects that they have to follow when they sign and seal plans that are prepared by an unlicensed person in the 1 and 2 family dwelling setting. And these rules require the licensed architect to take supervising responsible control over that design. And these architects have to meet with clients. They have to perform the calculations. They have to adopt the work that was done by the unlicensed architect as their own before they seal these plans. So although there are things Mr. Feldman can't do, there are things that he can do, and there are rules in place that allow for that process to take place and actually facilitate, as the legislature, I believe, intended, the exemption from licensure for drafting residential plans for a limited scope of projects. Mr. Feldman doesn't design high rises. He designed high rises in other states or other countries, where he's allowed to, but he certainly doesn't design high rises in Florida. That would be illegal. That's the unlicensed practice of architecture. But drafting residential 1 and 2 family dwelling or townhouse plans and specifications that are sealed by a licensed architect for purposes of permitting is perfectly legal. It's a legal activity. He's an architect. He performs limited services as an architect in Florida.
Counsel, if I could ask a quick question. I'm sorry to interrupt. As I understand this case, I mean, the board brought a 3-count complaint. 2 of those counts were dropped, correct?
Correct.
Okay, and one of those counts was the unlicensed practice of architecture. So they've dropped that count. Is that correct?
That is correct, because
so this case has a very narrow issue. And the issue is whether it's simply the use of the word architect in, I guess it was a LinkedIn profile and a website of some sort. Use of the word architect is a violation of the Title Act that the board enforces, the mere use of the word. Correct?
Yes, it is a very narrow issue, yes.
Okay, so whether the exemption applies or not, that sounds to me more like an as-applied problem. If the board had come after him saying, well, you really don't fit within the exemption, you're really practicing architecture outside the exemption, we would have a fuller factually developed record for that. We don't. All we have is one fact. He used the word architect, and he's not licensed in Florida.
I think if you, in the record actually goes back all the way to the initial administrative complaint being filed and the case having been sent to the Division of Administrative Hearings. And the initial administrative complaint did actually overcharge Mr. Feldman. It charged him with practicing without a license, even though the project he was involved with and contracted to perform the services, the drafting services, was within the exemption. He was also charged with not having his business not having a certificate of authority, which isn't required if you don't have a licensed architect qualifying your company. So those were overcharges. They were meritless to begin with.
Well, getting back, if I could get back to the claim in this case, the First Amendment claim that your client says he can use the word architect in his essentially commercial speech. Is it a fact in the record that he changed his website to say no architectural license for the state of Florida? Is that in the record?
That is correct. It is in the record. And he did that at the behest of the board. The first time they cited him, that was the instruction that they gave him. And that's what he did. He has more than one website. He has one website dedicated to Florida, and it does have that disclaimer in it that he is not an architect in the state of Florida, but it still showcases residential projects that he's done in Florida, which fall within the exemption of licensure.
So the three things we're looking at is the website where there's no architectural license for the state of Florida is included, and the use of the Spanish word architect and his LinkedIn profile. Those are the 2 or 3 items. I don't know if it's 2 or 3 items, but those are the 2 or 3 things that form the factual basis for the disciplinary action.
Yes.
Okay, thank you.
Could I go back to your earlier argument? Then you were talking about, somebody else has to, a certified architect or somebody else has to sign off on these plans. Is it then your contention that there's no safety issue involved in a non-licensed architect, in your language, being able to draw up these plans, and therefore the state doesn't have any, compelling state interest or rational relation or whatever the standard of scrutiny is in determining who can be called an architect?
That is correct. There is no public harm in allowing a person without a license to prepare plans and specifications for the construction of 1 or 2 family dwellings or townhouses. And that exemption, and I know that this was identified in the answer brief, that exemption seems to be consistent throughout the US. That there is and some states are actually more broad in what they exempt from architectural licensure, and some are a little more restrictive. But in Florida, in our state, the board has implemented these rules, and the board is very strict about imposing those rules. And they do ensure that the public is protected when an architect partners with an unlicensed architect who has prepared these plans and specifications. So yes, Your Honor, that is my point. Are there any other questions for me? I'm kind of blurry on the time.
You're about into your rebuttal time, but
yes, I think so. I'll stop.
You contend that this is the similar to the Byram case from Texas, but wasn't that more of a naming case as opposed to a licensing case? Is that it was Byram versus Landreth from the Fifth Circuit, where the interior designers weren't allowed to use that term. Wasn't that more of a titling law than a licensing law and therefore somewhat distinguishable from what we have here?
I think that this is the titling law. I think this is what is that challenges the licensing law. And I do think it is similar to Byron, but I also think it's actually very, even more so to Abramson v. Gonzalez, which is a Florida case involving, at the time, at least the legislation at that time, involving psychologists. And at that time, apparently psychologists didn't have to be licensed, but they could be licensed. And the unlicensed psychologists were allowed to advertise their services and perform those services because it was lawful activity that they were allowed to do. And it did not mislead the public. So it is a titling statute. The Practice Act is not being challenged here. Mr. Feldman knows exactly what type of plans and specifications he can prepare in Florida. He knows what that exemption is, but it is more about the title. And if he's performing these services and he's performing them lawfully as allowed by the statute, he's just not allowed to say it. He can do it, but he can't say it.
Counsel, if we accept your argument, what effect will our holding have on the state's other long-standing regulatory schemes? With doctors versus non-doctors, lawyers versus non-lawyers, nurses versus non-nurses?
Well, I don't believe that all of these other professional statutes have exemptions such that are similar to the architectural exemption. I don't know of any exemption for lawyers. I don't know of any exemption for doctors or any other profession that would allow people to practice a limited scope within that profession. And on the other flip side, if a doctor is a doctor in California, if he comes to Florida, he's still a doctor, and he can say he's a doctor. He just doesn't practice as a doctor because he's not licensed. And what Mr. Feldman is saying is, I'm an architect, but I can practice a very limited scope of architecture in Florida. I just can't say it. So there are less restrictive means by which the state's interest can be accomplished. And maybe that's along the lines of a disclaimer, which are favored. Maybe it's along the line of revised legislation that is related to some type of a different title for this particular exemption. But this is an all-out ban. And that is what infringes on Mr. Feldman's free speech. And I know I am moving into my rebuttal time. So unless your honors have any questions, I'll stop.
Thank you, counsel.
Thank you.
Good morning, your honors, and may it please the court, David Costello for the Department of Business and Professional Regulation. Laws preventing non-professionals from representing that they are professionals are the cornerstone of any state regulatory scheme. Non-doctors can't call themselves doctors, non-lawyers can't call themselves lawyers, and non-architects can't call themselves architects. Now, I don't think Mr. Feldman disagrees with those principles in the ordinary course. Instead, he says the First Amendment prohibits the state from preventing him from calling himself an architect in Florida because he's actually allowed to practice a form of architecture in Florida. But that is doubly wrong. It is inherently misleading for Mr. Feldman to claim that he is an architect to generate business within the state. And even if it is not, the
why
state's
is it misleading, counsel? Why is it misleading?
Well, it's misleading for a few reasons, Your Honor, because when a person calls themselves an architect, they are representing to the public at least three things, none of which are true for Mr. Feldman. The first is that the public would believe that a person who calls himself an architect to generate business within the state is lawfully entitled to provide all the services that an architect in the state can provide. And Mr. Feldman can't. He can't do many of the things an architect can do. He can't administer construction contracts, can't sign and seal plans in the public record, and he can't provide building code inspection services for the government. All he can do is perform some services for some family residences, and that's quite far afield from being able to do all an architect can do. And I think that a helpful example, Your Honors, is to think about this in a more practical sense. Think about the distinction between nurses and doctors. Nurses can do many of the things that doctors can do. They can draw blood, they can take temperature, they can talk to patients. But no one would say that a nurse is a doctor. And that's because when someone calls themselves a doctor, someone believes that that person can do all the things that a doctor can do. And Mr. Feldman cannot do all the things that an architect can do. And I think a really helpful way to look at this too, to know that the legislature intended to make sure that Mr. Feldman could not do all the things that an architect can do, is to look at the interior design exemption within the same statute, within section 481.229. And just as some background on that statute governs both architecture and interior design. And just a few paragraphs down from the provision that Mr. Feldman relies on, the legislature said in subsection 6A that the state's regulations shall not apply, quote, to a person who performs interior design services for any residential application. That does exactly what Mr. Feldman says he can do here. It allows a person to perform the full suite of interior design services just for residences. But the legislature didn't do that for the architecture provision. It did something quite different. It didn't say anyone can perform architectural services for any residential application. Instead, it said you can perform some services for some residences. And we think that that makes all the difference, because when the legislature uses different words in the same statute, we construe those words to have different meanings. And here the difference is clear. The legislature did not intend for Mr. Feldman to be able to do all the things an architect can do. And so he misleads the public when he calls himself an architect.
Well,
But that's not the.
can I ask you about that, Council? 481.229.1, it doesn't say it's not architecture to, draw up a single family resident. It says no person shall be required to qualify as an architect. I understand. I mean, if it was more clear that, it's not architecture to do X, then you don't have to be a licensed architect to do X. But the language doesn't exactly say that. Why should we read it the way you're saying?
Well, if I can answer your Honor's question by first differentiating the arguments that we have. So like I said before, there are three things that calling yourself an architect would convey to the public. One of them is that you can do all the things that an architect can do. And that's not related to, and that does not hinge on you believing that what the legislature was doing in the family residences carve out is actually carving out these services from the practice of architecture. That just rests on the idea that even if those things in the carve out are architecture, Mr. Feldman can't do all the things that an architect can do. But to directly answer your Honor's question, it is also misleading when someone says they're an architect if they actually cannot practice architectural services. And we think that in the family residences carve out, the legislature was carving out the services in that carve out from the practice of architecture entirely. And we know that for a few reasons. Look, first, if you look at the title of section 41.229, it makes clear that it's doing two distinct things. The title first says that it contains exceptions, and then there's a semicolon, and it says that it also contains exemptions from licensure. And we think that that is saying that some provisions in this statute are actually accepting certain kinds of services from the practice of a profession. So these things typically might be encompassed within the profession, but we are accepting them from the practice of the profession. And then some other provisions in the statute are exemptions from licensure. And the interior design exemption is a perfect example. There, the legislature is saying you can do all the services of interior design, you can practice interior design, but we're going to exempt you from licensure. And so the question then becomes, what side of the line does the architecture provision fall on? And we know that it falls within the exception side of the line and not the exemption side of the line, because the legislature uses very different language when they want to create an exemption. That's what they did in the interior design exemption. And here they didn't do that. Instead, they said one need not qualify as an architect to do these things. And we think that the legislature was simply recognizing that the reason you don't need to qualify is because those things aren't architecture. And if this court were not convinced just by that textual analysis and by looking at the statute itself, that reading tracks the industry standard for the practice of architecture, because the industry itself deems the services within this carve-out, within the architecture provision, to not even be architecture. The National Council of Architectural Registration Boards has a model law, and that model law makes clear that activities related to single family and dual family homes are not deemed to be architecture. So Mr. Feldman actually isn't practicing architecture under this carve-out, and so it is misleading to call himself an architect, because a person would think that an architect is actually practicing architecture within the state, and Mr. Feldman is not. And just on one last point, Judge Bilbrey, if you still weren't convinced and were a little concerned with this reading, we think that this court at the very least should apply the canon of constitutional avoidance to this subsection and construe it so that it faced with an ambiguity, it is actually carving these services out of the practice of architecture. And we think that's important because if this court does that, We don't need to get to intermediate scrutiny. We don't need to get to interest weighing. Instead, Mr. Feldman's calling himself an architect would be inherently misleading because he's actually not able to practice architecture within the state.
Well, counsel, if I could ask a question, let's say you have an architect who's licensed in the state of Georgia, and he happens to reside in Florida, but does, part of the year at least. He's lawfully licensed to practice architecture in Georgia. If he has a website out there that says he's an architect, that's truthful, he's licensed in Georgia, does the state of Florida say, well, you're holding yourself out to offer services in Florida, therefore you're in violation of our Title Act?
Well, I think that's right, Your Honor. I think the state of Florida would do that because even though he is licensed as an architect in Georgia, he's not licensed in Florida. So the state has not had the opportunity to verify that Mr. Feldman, in fact, is qualified to the standards that the state sets. Now, Mr. Feldman.
So the state of Florida would go after a Georgia architect who happens to have a website that gets hits in Florida.
Well, not that it gets hits in Florida. I think that we would say that there is a closer connection required by the statute, that they're actually marketing their services in the state.
Okay, well that leads to my next question, which is I look at this record, I think it's a real stretch to conclude or infer that Mr. Feldman is essentially holding himself out to do the whole range of architectural services in the state of Florida, which you seem to hang your hat on, which is that if he uses the term architect, he must, I forgot the phrase you used, he must do all the things an architect can do. And that seems to me to be that seems to be at odds with what the free speech clause of our Constitution is about.
Well, to give a prelude to the question, then to directly answer the question, Your Honor, I don't think that our argument hinges on Mr. Feldman being able to do all that an architect can do. We think that there are at least three things that Mr. Feldman is conveying that are misleading. One of them is that he can do all the things that an architect can do. Another one.
Wait, he doesn't say that anywhere. And in fact, he specifically says, I'm not licensed in Florida. So how can you come to that reading?
Well, I think that we can come to that reading for a few reasons. But first, I'd like to clear the underbrush. The count here that the board proceeded under, as Your Honor was recognizing in my friend on the other side statement, rested on two uses of the term architect. One was in his website, and that did contain a disclaimer that says, I am not licensed to practice within the state. But the other one was on his LinkedIn, and his LinkedIn contains no such disclaimer, but still recognizes that he's in Florida and discusses his services that he provides within the state. And so we don't think that our count just rests on the website itself. We think that this court can affirm the board's judgment based on the LinkedIn alone. But we also don't think that the website's disclaimer was actually did any work to convince anyone that he's actually not able to perform services within the state of Florida. For example, that disclaimer, if you look at it, it's a very, very small print at the bottom of the page. To get there, you'd have to scroll through lines and lines of him calling himself an architect. It's effectively the equivalent of putting on a billboard, I am an architect, in big letters, and then in fine print in the bottom right, I'm also not licensed in Florida. We don't think that would convey to a reasonable person that, well, actually, I can't do what an architect can do within your state.
But on that point, that's not a factual finding in the record here about what the font size was and all that. It's basically the pure legal question we have is whether the use of the word architect here, or the prohibition on this gentleman using the word architect, is unconstitutional.
That's right, Your Honor. That's right. Of course, we do think that this court can review the record on its face for itself. It wouldn't need to have a specific factual finding that the font was incredibly small. But even taking that at face value, Your Honor, we don't think that disclaimer is really helpful to begin with, because when someone thinks of an architect or thinks of a professional, they think that person with their marketing services within the state has actually been vetted by the state and is qualified to practice within the state. And so when someone says, I am an unlicensed professional practicing within your state, that would just be incredibly confusing to the public, and it would mislead them so that they would not really understand what is happening. And I think that strikes to one of the interests that we explained in our briefs, and that's the idea that you can't. The reason we have this law is because we don't want individuals to be duped into entering contracts with people that can only perform, some of the services that an architect can perform. And as my friend on the other side recognized, there are many things that Mr. Feldman can't do, and those things would even be essential to practicing under the family residences carve out. He'd have to have an architect sign and seal plans in the record for him, even though he's done services on this family residence. So we do think that the law has force and is advancing substantial state interests. But I'd also like to note, Your Honor, that even putting aside the do all the things that an architect can do point, when a person calls themselves an architect and they are practicing within the state and they're marketing their services within the state, another thing that the public would believe is that that person has actually been vetted by the state in which they are performing their services. And Mr. Feldman's has not done that. Mr. Feldman hasn't been vetted by the state. He hasn't taken our licensure exam, and he had all the opportunity in the world to take our licensure exam. He just refused to do so. And so here, when he calls himself an architect, a reasonable person would think that he's actually been qualified by the state of Florida because he's marketing his services as an architect in Florida, and he simply has not been. So it is inherently misleading for him to call himself an architect, and this court's analysis can end there as a legal matter. There doesn't need to be any fact finding.
Well, what if I'm an international architect? I'm coming from France, and I build some of the world's most fabulous structures, and I come to South Florida, and I put a LinkedIn profile up, and I use the phrase, "I'm an international architect," and I live in the Miami, Fort Lauderdale area. Is that enough?
We think that it's enough to be a violation of the statute, and we think that it's enough to survive First Amendment scrutiny, because when someone says, "I'm an international architect, here are services."
Whoa. But I'm retired. it didn't say on my webpage, but I'm retired. I don't hold myself out to the public anymore. I'm just an international architect.
Well, two things, Your Honor. First, I would want to know that that's not this case, because Mr. Feldman didn't say he was retired, but I take the point, and I don't want to fight the hypothetical. In that instance, I think that Your Honors would take it, could apply the canon of constitutional avoidance to take a narrow view of this statute, so that it's only applying when someone is actually marketing their services to the state, like Mr. Feldman was doing here. So we don't think it would cover someone who is a retired architect that just happens to say, "Hey, I'm a retired architect." The point of the statute is that we are trying to make sure that people who are marketing their services aren't misleading the public about their qualifications.
So if I go to a party and I'm trying to impress people and I say I'm an architect, that's not something that DBPR would act on, even if I'm not an architect. It's
that's right, Your Honor. I've actually thought about that. That's right. I've actually thought about that myself, because I've been in other states and I've said I'm a lawyer, and I want to make sure that I'm not violating a title act in those states. And I think the idea is that the point of these title acts is making sure that someone is not misrepresenting themselves. Excuse me, I'm getting a hurricane alarm. That someone's not misrepresenting themselves in the course of marketing their services within the state. Because that's the real thrust of this law. The DBPR has no interest in someone at a party just saying, "Hey, I'm an architect," because that's just cocktail talk.
If I could focus a little bit more, the department initially went after him for the unlicensed practice of architecture, but I guess as it turns out, he's actually not doing that. He's actually providing services such as plans and specifications, and perhaps supervising the erection, enlargement, and alteration of residential structures. So what he's doing is lawful, correct?
It is lawful. Yeah, of course, it is lawful.
Okay. So and those same services are within the ambit of what you described as things architects can do, correct?
That's correct, Your Honor.
Okay, it doesn't make him an architect because he can do those things. In fact, my suspicion is that the exception here was put in because architects wanted it. They wanted to have people on staff who are not architects who can do the plans and specifications and other things that they don't want to do.
And if I can make an amendment, Judge Makar, yes, architects can do the things in the carve out, but that's because everyone can do the things in the carve out. They're not practicing architecture when they do those things, even though they're architects.
Can you, I'm sorry, go ahead, Judge.
Oh, no, go ahead. No, please go ahead.
I was just going to ask about the Locke case because that featured prominently. in some of the arguments. Could you just distinguish Locke and say why that doesn't apply here?
Yes, Your Honor. I think there are two main differences from Locke of this case than from Locke. They all boil down to one basic premise, and it's that Judge Hinkle found in Locke that a person could provide the full suite of interior design services and practice interior design for residential applications without a license. They were not subject to regulation. That's not what Mr. Feldman can do here. Mr. Feldman is not practicing architecture under the carve-out. He can't do all the things that an architect can do. And so this case is quite distinguishable from Locke. And indeed, the interior design exemption makes that perfectly clear, because the exemption says, and this was the language that troubled Judge Hinkle, you can perform interior design services for any residential application. In other words, you can do all the things related to interior design just for residences. And so that makes you an interior designer. You just do it only for residences. But that's not what we have here. Mr. Feldman cannot perform architectural services within the state. And even if he could, he can't do all the things that an architect can do. He can't provide the full suite of architectural services. So Locke does not apply here for that very reason. And we think a better example of ARC sort of case is Bowman, because in Bowman, people were not actually, accountants were not actually allowed to practice accounting to the level of a certified public accountant within the state of Virginia. And so the Fourth Circuit said, well, the title law in Virginia that prevents you from calling yourself a public accountant survives under the First Amendment, because a reasonable person would think that you're actually able to do those things within the state, and that you're able to practice accounting, and that you have the state's imprimatur. And Mr. Feldman doesn't have the state's imprimatur here, and he's not actually able to practice architecture or do all the things that an architect can do. And so when he says that he's an architect, he's misleading the public, and the First Amendment analysis can stop there. But even if this court were not to believe that that Mr. Feldman is misleading the public, this regulation survives under intermediate scrutiny. And to do so, we have to show that the regulation is a reasonable fit for advancing substantial state interests. And this law passes that test. And I think that the main interest that I focused on before is that we have this law to make sure that consumers are not lured into contracting with a person that they think can perform all the services associated with architecture. And as my friend on the other side conceded, there are many things that Mr. Feldman simply can't do. And when a person contracts with him to build their home, they're also going to go have to find someone else or contract someone else to get the job across the finish line. And so that's why we have this law, because we want people to be able to know, I can go to an architect and they can handle all of this for me and practicing within the carve-out. But Mr. Feldman is not able to do all of those things. And so I think that this case is the perfect example of our law advancing our state interests. And I think Mr. Feldman's main point on this intermediate scrutiny argument is that we haven't provided empirical evidence. But as we explained in the briefs, as Falanga and as the US Supreme Court said and went for it, we don't need to do that. If we can show that history, consensus, and common sense support our law, we can survive intermediate scrutiny. And I see I am running out of time, but I think that we've done hopefully a good enough job of explaining that in the briefs. So for all those reasons, Your Honors, we would ask that this court affirm the order of the board. Thank you.
And thank you, counsel.
Thank you. May I proceed?
You may proceed, counsel.
Thank you. I would like to touch briefly on the distinction that Mr. Costello made with regard to Locke v. Shore in regard to the interior designers. The state's position is that in Locke v. Shore, the court basically held that interior designers who were not licensed but doing residential work, which did not require an interior designer license, could do everything that a licensed interior designer could do, but they could only do it in a residential setting. That really is the same thing that we are dealing with here with regard to Mr. Feldman. And the reason is because what are the things that a residential interior designer can't do in a commercial setting? Well, number one, when you get into commercial interior design, the license is required because interior designers are dealing with public access, buildings with public access, and they are getting into fire rated materials. They're getting into furnishings that don't obstruct the access and egress to the building. They are getting into accessibility codes. There's a lot more that goes into a commercial interior design project than a residential interior design project. In fact, commercial interior design projects, the plans, the interior design plans are prepared by a licensed interior designer, and they're sealed by a licensed interior designer, and they're submitted to the building department for plan review along with all of the construction documents, along with all of the other plans and specifications. So a residential interior designer can't do any of that. This is why they are limited to a residence, because they're not dealing with public accessibility structures. And Mr. Feldman is not dealing with public accessibility structures either. He's dealing with 1 and 2 family dwellings or townhomes. So Locke didn't expand what a residential or unlicensed interior designer could do. They just, what Locke said is, and this was not challenged on appeal either, the residential, the unlicensed interior designer can lawfully do residential interior design projects, and they can say that they do it. It's truthful, it's legal, it's lawful activity, and they can say it. And that's the same thing that Mr. Feldman is doing here.
Well, can I ask you, counsel, under the 481-229, parens 1 and parens 6A on interior design use different language. The part applicable to Mr. Feldman is no person shall be required to qualify as an architect, you know, and then so on. Whereas for the designer, it says this part shall not apply to. So the legislature has used different words. How are we to, are you saying we should interpret those the same?
Well, I think that when you say that, when the legislature said that no person needs to qualify, that means that they can do the work without the state vetting that Mr. Costello has talked about. And that seems to be true nationwide with regard to certain residential types of applications. Now, as far as this part shall not apply, I think that language, was a revision to that particular section of the statute. I'm not sure, so I don't want to misrepresent, but I think after Locke v. Shore, the statute was amended to reflect that particular language. And I don't want to ask Mr. Costello, but that's my understanding. If it wasn't revised and that was the original interpretation, I don't know. I don't see any difference between shall not qualify or shall not apply. What they both mean is you don't have to do this. You don't have to do this in order to do that. I don't have any other rebuttal comments unless your honors have any more questions for me.
Thank you, counsel.
Thank you.
And thank you, counsels, for your respectful oral arguments this morning. This concludes our oral arguments for this morning. We are adjourned.
Thank you.
Thank you.
Thank you.